Hello and welcome. I am Dissecting here and you're watching Politics Today on a night, when there have been major developments across the country, especially a major development, I should say, especially beginning from Friday when the Supreme Court of the land gave that judgment now sacking 5 governors of the country. So as we speak, in 5 states of the country, you have the speakers in charge. Now, those speakers are going to be in charge, but we do not know for how long. The Supreme Court gave that decision, and just to give you a background now of how this whole thing started, how, the case started, and what eventually led to the removal of the governors, I have put together this report I want you to take a look at. Let's take a look at this. The 10-year elongation saga actually began as far back as 2010, when the 5 affected governors approached the Federal High Court in Abuja to extend their tenures, bearing when they took their oath of office as governors. All 5 governors had taken part in court-ordered rerun elections after the original elections had been nullified by the court. By February 2011, the Federal High Court agreed with their argument and extended their tenures. In granting the order, Justice Bello cited Section 180, subsection 2 of the 1999 Constitution to fix the expiry dates for Governor Ibrahim Idris of Kogi State as April 9, 2012, Aliyu Wamako of Sokoto State May 8, 2012, Timipre Silva of Bayelsa State May 29, 2012, Murtala Nyako of Adamawa State April 30, 2012, and Leah Limoke of Cross River State August 28, 2012. The judge also ordered INEC to conduct elections in the affected states 60 days to the expiry date of each of the governor's tenure. But INEC, which had by this time issued a notification that it was going to organize governorship election in the affected states in April 2011, appealed against the High Court ruling. That appeal failed, as the higher court upheld the verdict of the lower court. Still not satisfied, INEC headed for the Supreme Court, where the case has now been resolved in its favor.
The judgment of the Supreme Court is final because the Supreme Court is supreme. And the Supreme Court's judgment is supreme because it is final. There is no further appeal. It has to be accepted and respected by all Nigerians.
Judgment merely says that, look, their terms have ended. But having ended, they cannot just pack and leave the office. The Constitution provides that they can leave office only when a successor emerges.
A governor is supposed to be a representative of the people. And the fundamental assumption of our Constitution is that we would have regular change of government. And the setup is that it will be done every 4 years. So the decisions of the 2 lower courts that suggested that governors could be in office for a day more than 4 years were clearly elements of injustice to the people. So it's great news.
But the judgment leaves in its wake some bit of confusion, especially in Kogi and Bayelsa states. It is not very unlikely that we may see some people head to court to determine which party primary should be recognized as valid. For instance, in Kogi State, the contention may be which between the PDP primaries held in January 2011 and September 2011 is valid. By the way, both primaries produced 2 different persons as candidates. It is also a similar situation in Bayelsa State, where the January 2011 PDP primary produced Governor Timipre Silva, while the November 2011 primary produced Siriake Dixon as candidate of the PDP.
I think, honestly, that Silva will be hard put to say that it is the last primaries, the primaries that was held last year that is valid, and not the one that was, the first one that was held, and not the second one, because he took part in the second primaries. So, a man cannot allow to eat his cake and have it. You cannot reprobate and approbate. He can't blow hot and cold.
As for the other 3 states, we're not likely to see any drama, since the incumbent governors there won both primaries of their party. So, the legal fireworks may just be starting for both Bayelsa and Kogi states. Well, as you heard there, beautiful judgment. That's how some people have described it. But then a whole lot of confusion the judgment has thrown up, and lawyers from left, right, and center are weighing in and giving their own interpretation of what is likely to happen in Bayelsa and Kogi states. But just before we come to that, let me just tell you that the PDP has been reacting to that judgment. The PDP actually issued a statement not quite long ago. And I'm just going to read from that statement. It says, the People's Democratic Party wishes to express its dismay and bewilderment over the judgment of the Supreme Court in which 5 governors elected on the platform of the party were removed from office in one fell swoop. He goes on to say the judgment no doubt throws a major challenge to our determination to deepen democracy in our country. For us in the PDP, it says it is a huge setback considering the time and resources spent in the last 1 year to ensure smooth transition in the affected state, and that while we await a clear position from the Independent National Electoral Commission on the status of election in these states, that's the 5 states now, we call on our members to remain calm and be rest assured that we shall continue to stand by them and do everything legally possible to maintain our dominant position in those states. The acting national chairman of the PDP, Alhaji Kawu Abubakar Baraje, on behalf of the National Working Committee, wishes to express solidarity with the 5 governors and, well, I should say 5 former governors, but I'm just reading the statement now of the PDP. With the 5 governors, and wishes to assure them that the leadership of the party shall spare no effort in ensuring that the current situation does not derail our preparation for elections. That statement was signed by the spokesperson of the PDP, Alhaji Professor Rufai Ahmed Al-Kali. So that's the position of the PDP. The PDP coming out with a statement today over that judgment that took place on Friday. But let me just say this as well, that we're getting information that INEC will be sitting tomorrow, and that by tomorrow we'll be hearing for INEC what its position is. But, pending that time, we will still be dissecting that Supreme Court judgment. And joining me on the program right now, I have 3 lawyers who will be dissecting the judgment of the Supreme Court and also be looking at the implications. Sitting very close to me is Mr. George Eke, who is a legal practitioner. I also have Mr. G.T. Ogunye, who is also a legal practitioner. And I have Mr. Chijioke Emeka, also a legal practitioner. 3 lawyers, as a matter of fact. And in the course of the program, we shall try to establish contact on the phone now with some other lawyers to give us their own analyses of this judgment. But let me start with you, Chijioke. What do you make of the judgment?
Well, the judgment, I have said elsewhere, has restored what I call the spirit of our Constitution. This is to say that if you look at the legal arguments against the position taken by the Supreme Court, and you start looking at the letters of the Constitution, you may be in a position where you start wondering whether it's actually what the Constitution has said. But looking at the intendment, what I call the spirit of the Constitution, which I believe must forbid a person spending 7 years because he's doing one term, 8 years, or ad infinitum. I think that this judgment has restored the spirit of the Constitution. That is to say, it is not possible for a person to be elected for a 4-year term, and then the person, because the election was annulled, goes back, reruns, comes back, because you can see a situation where that can continue. Before the person is out, he has spent 18 years doing one tenure. So I think the judgment should be welcomed by all and sundry.
But let me ask you, Mr. Ike, I know you were on this program some time ago, when the case was in court, and you actually supported the argument that, the court should not grant them any kind of extension at all, that these 5 governors ought to have ended their term in May, and this would appear to be some kind of vindication of your position.
Well, this profession of law is that you must always see people arguing from the other side. That's the beauty of the profession. There's always something to say on the other side. But you see, at that point in time, I had said that the trial court at that point in time erred in law, by my own view, that they did not look at the canons of interpretation that they were seized with The reason is that they went on a literal, there are canons of interpretation, that is to say how a judge can interpret a particular statute or a particular law. The literal interpretation canon says, just interpret it exactly what the word says. Don't bother looking for other meanings and all of that, exact meanings of the word. But again, it warns that in interpreting it literally, if it's going to cause absurdity, the result of that interpretation is going to cause absurdity. Don't use the literal interpretation. Go for the golden rule. The golden rule is that you avoid that absurdity. And of course, you see that we have been vindicated. What was the result of the literal interpretation? Is that a number of governors won election, and the election was contested, or at least challenged. They all stepped aside, as it were, and recontested the election and won. It's not an accident that the 5 governors that the elections were all challenged had to win the election. Of course, it is part of the political dynamics of our country. 5 of them, none of them lost the election. In other words, a number of them had 2 years before then, and in interpreting the time of office begins to run, the trial court started interpreting, time started running from the second oath of office, as if the other oath of office had been nullified. And of course, my view then was that we should work from answer to question. What is the intendment of the law, the lawmakers? What did they have in mind? Like my colleague said, the spirit of the law. What did they? And that is exactly what the route the Supreme Court now came from. Could it have been the intention of the Nigerian people that their governors could stay about 12 years in office? The answer is no. In short, some of them were heading for 11 years. Some of them were heading for 12 years. 10 years. And of course, that couldn't have been the intendment of the lawmakers. It was not the desire of the Nigerian people, and couldn't have been within the contemplation of the Constitution itself. So, but you see, the trial court and the appeal court all kept looking at it from a literal standpoint. What does the letter of the Constitution say? Without looking at the spirit. In other words, what we said a year ago is what the Supreme Court has just vindicated.
And you must be happy about that.
I'm not sure without that.
Let me ask you, Mr. Agunye, did this take you by surprise, the judgment? Are you surprised at all?
No. The only surprise I have is that the judgment is coming too late. When this whole debate started, I made a public contribution to the debate, which was published in the Punch, in the law pages. And the article I published therein was titled, "When Will the Tenure of Governors Who Want to Run Elections End?" And in that article I submitted that it will be absurd to propose that their tenure will end, years after they were first sworn in, which inevitably will amount to a tenure allegation. Therefore, I'm not surprised that this has happened because of certain reasons, and I will just give you these reasons.
Okay.
Look, what is going on now, what has happened, had a background. The background was that there was a situation in Anambra State.
Of course.
Before that situation, nobody, look closely, take a hard look at Section 180 and then the implications of the provision of that section in life situations like that. And the INEC of that era insisted that an election must be conducted. And indeed, it went ahead to conduct an election no sooner than the governor was sworn in then. And Mr. Andy Uba became a governor.
For 17 days then.
For 17 days. And the court then came in, Supreme Court again, and said, no, that mandate you claim to have obtained was not a mandate properly so called. And even the latter attempt to revive that mandate also failed at the Court of Appeal when Chief Olani Beku, took the matter to the Court of Appeal to see whether that mandate could be revived. But the point was that that was the beginning. And so the decision of Obi and INEC reported in 2006 Nigerian Weekly Law Report, part 1046, came about. And so what these governors did essentially was to latch on to that judgment.
And were they wrong?
And they were wrong because the facts were dissimilar. Okay? Before these governors, did that, Nigerians have also forgotten that Governor Rashid Ladoja also wanted to exploit that same judgment when he went back and said, I was impeached, and so I was out of power by 11 months. And so, please normalize my tenure so that I could spend another 11 additional months. And of course, the Supreme Court rebuffed that and said, no.
But I have to ask you, now, in the case of Chief Rashidi Ladoja, when he was reinstated by the Court of Appeal then, he didn't have to take another oath.
Exactly. And that's the point the Supreme Court made, that, look, your case is different from the case of Governor Peter Obi.
No, but in the case of these governors, they all took fresh oaths after the one.
Exactly.
Yeah.
But I now come to the reasons. Look, this principal canon of interpreting a constitution is as stated in the case of Attorney General of Bendel State and Attorney General of the Federation by the Supreme Court, and said that the Constitution is a complete document. So it's an integrated document. In interpreting it, therefore, you have to look at all the provisions all together, not one section in isolation of the other. And that the Constitution is an organic scheme. This is not my language, it's the language of the Supreme Court. That there's a schematic here. And the schematic is that whether you're talking about the president of the country or governor of a state, the tenure recognized by the Constitution is 4 years certain. So if you then have a situation in which we had an election and the result of that election was annulled by the court, and that then led to fresh elections, you cannot insist that because you took a fresh oath of office, that cumulatively the period you are going to spend will exceed those 4 years.
All right, I'm still going to come back to you. Let me ask you this, Mr. Emeka. I mean, from what he has said, I mean, we're looking at, he said the case of Obi and these other 5 governors very dissimilar, but we're talking about a case that involves, a fresh taking of oaths. In the case of these governors, that they took fresh oaths after that. Do you think, when you look at it from another angle, some people have said, well, this could amount some kind of reversal, that it's like the Supreme Court was trying to reverse itself, in terms of, that's looking at the judgment now it gave in the case of Obi now, that the Supreme Court was trying to reverse itself because the same Supreme Court said, your tenure will begin to count from the day you take the oath of office of governor.
Yeah, I don't see that as a reversal. The reasons are this. First of all, Governor Peter Obi took one oath of office. Governor Peter Obi was not in office at all before he took that oath. You recall that what happened in Anambra State.
Yeah, I'm just saying from the judgment given.
No, I'm coming to that. I'm coming to that because that's the background. Ngige was in office for about 3 years. Peter Obi came and took an oath of office. Okay. Now, when these governors took the first oath of office and the election was nullified, the second oath of office they took was not necessary. That's the meaning of the Supreme Court judgment. And the Supreme Court has said in this judgment, well, that oath of office you took, the second one, was not necessary, but it was superfluous. So that's what the Supreme Court said.
I have to ask you this question, and any of you could take on it. Could we then say that the amendment of the Constitution, that section of the Constitution that the lawmakers amended not quite long ago, stating that if you run for an election and you win that election, eventually your election gets annulled, you recontest and win, that your term of office will begin to count from, if you won the rerun now, that your term of office will begin to count from the first election you won. So this judgment makes it useless. The lawmakers should not have bothered at all to amend that section of the Constitution.
No, I disagree with you. The reason is this. The lawmakers wanted to make it very specific because there was a constitutional lacuna. Nobody envisaged the scenario that emerged with these 5 governors. A situation where people contested or challenged their elections and they now had to take a fresh set of office, a fresh oath of office. And based on the fresh oath of office, a number of them now argued that their terms started running from the second oath of office. In other words, if anything, the Supreme Court has just validated that amendment of the Constitution.
Is that the case?
Oh, sure. They just validated that amendment of the Constitution. In other words, what the amendment is saying is that your term begins to run from the first oath of office that you took, which is exactly on all fours with this judgment that the Supreme Court has just given. So it is not a reversal. If anything, it is a validation of that part of the Constitution. But what that amendment has now done is that it is no longer in doubt. It's no longer subject to arguments, because it has expressly said that if somebody wins an election after a rerun and he had an earlier oath of office, that the term of office begins to run from the first oath of office.
Let me ask you this, Mr. GT. I mean, for these governors, we're talking about them just because they won the rerun election. If someone else had won the rerun election, what would have happened?
That would be a fresh oath of office, and so it will have its 4 years.
Or basically,
that's what it means. Look, what the Supreme Court has just done is a vindication of the position that was long held. That, look, in enforcing a private right, which in a way graduated to a public right, because once you secure a mandate as a candidate and you become a governor, that's in the realm of a public right. In enforcing that, you must take cognizance of the bigger right of the electorate. And that was the schematic I was talking about. Look, the right of the people to periodically elect a government of their choice is an international right. And in our circumstances, that right is stated in the Constitution. When the term or tenure of a governor is specified, when you say, for instance, that a governor who won a rerun should start a fresh mandate, what you are doing is that you are affecting the right, the greater right of the electorate to have a governor run their affairs every 4 years. And so you are saddling them with a governor for 5, 6 years or 7 years, as the case may be. That's not the intendment of the lawmaker. That's not the intendment of those who made the Constitution or those who frame it.
I want to ask a question. I want to ask you this, Mr. Meka, but you know, this is a question we also put to a senior advocate of Nigeria out there. The question is, what happens to all the actions that these governors had taken? We've been told now that, you know, their tenure should have ended May. So what happened to all the decisions they took in office after May 29th? Just before you give me your answer, I want us to take a look now at what the senior advocate of Nigeria had to say about that. Take a listen.
Everything that is done by a man that occupies the office of governor, no matter how he got there, according to the provisions of our Constitution, is valid. Therefore, Obasanjo that got to office by military coup, Murtala that got to office by military coup, Babangida, Abacha, Shonekon, that all got into office other than by provisions of the Constitution. Everything they did remains valid. And the Electoral Act also specifically says everything that a governor does or a person does while in office as governor is valid, irrespective of the fact that he got to that office, you know, wrongfully. So, you know, it's clear that everything he does is valid.
All right, that's the senior advocate of Nigeria, Councillor Ajayi. Let me get your own reaction now.
Yes, I agree totally with the submission of the senior advocate. We have a precedent. The Supreme Court came out to say when a similar issue arose in Anambra State, the same P2B and Ngige issue, by virtue of the powers conferred on the governor to proclaim the House of Assembly. Ngige had proclaimed the House of Assembly before the Court of Appeal said he was not properly elected. I was P2B that was elected. The House, some people went to court and argued that the proclamation was invalid. And the Supreme Court said everything done while he was presumed to be the legitimate, or what they call the de facto governor, was valid. Supreme Court entered into that in this present judgment when the Supreme Court said that the position of the lower court that these 5 governors' election was null and void ab initio was wrong. That actually what happened was that the elections were voidable ab initio. So being voidable, it means that everything they've done have been saved, even if you say by the doctrine of necessity. We also have what we call presumption of regularity. So everything done by the governors, we can't, it will be chaotic if you say that you go back, all the contracts signed, all the laws, bills signed. So
this is a very interesting point. I'm going to ask a follow-up question from that, but let me get your view on that, Mr.
Correct. But ask me that follow-up question. You can't anticipate the question you're asking.
You can't be anticipating. Just hold on. You can't be anticipating. Okay, but that's a smart one anyway. That's a smart move. But let me get your views on that. I mean, all the actions valid, proper?
No, I've once said this on this program that it stems from this logic. At a point in time when they were elected, the election was conducted by INEC. INEC is a properly constituted and constitutional authority to conduct election. And so properly called, it was lawful. If they were sworn in at that point in time, it was also lawful. At that point in time, if the election got voided later, within that period that it had not been voided, whatever they did was lawful. Because if like my colleague mentioned, if you go back to begin to reappraise the decisions, policies, proclamations they may have made, you are going to find out that you're almost going to wipe a whole generation of policies and contracts. In short, at particular points in time, you notice that these governors may have signed the death sentences of quite a number of prisoners, and they may have been executed. Are you going to recall those people from the grave? It had been done, and it is valid at that point. It was valid at that point in time. It remains valid up to today.